Hi everyone, I'm JD Hoovener, the host of the Bold Today Show, where you, the inventor, business owner, or entrepreneur, get your daily dose of inspiration to make the world a better place. And we're on day 3 of a 5-part series about software and how software patents have really become quite the news story lately. This year opening up quite a few different decisions by the Federal Circuit, and we're hoping from the Supreme Court to say that, look, software patents are eligible. And I'm going to talk about one of the big cases that's recent about this whole situation. So we talked yesterday and the day before opening up, okay, what is subject matter eligibility all about? How software falls into the categories of machines or processes. And then we talked about the foundational framework basis of the decisions that have come up in 2012 and 2014 with Mayo and Alice. So with that understanding that those cases have said that, look, computer implementations of ideas that are abstract or that don't do anything functional, that doesn't transfer any type of explainable or transferable media that's touchable and tangible, it's not eligible. Now, that is actually still the case, but some very recent Federal Circuit decisions, as we're going to go over today and tomorrow, have changed that landscape. So the case I want to talk about today is about software virus scanning, and a case that went before the Federal Circuit is called Finian versus Blue Coat. And so this case was all about how Finian, who owns the patent about computer virus scanning, and what they argue successfully to the Federal Circuit is that they don't just do virus scanning. Their claims say that they actually identify malware or code that looks threatening, that's going to do something harmful to one's computer, and then they categorize it and dispatch it, right? They actually able to report on bad code in a proactive manner, as opposed to traditional virus scanning, which simply reads over the code and then identifies. Finian's software system, what they've claimed, takes that action without seeking that validation from the user, right? They sort of imagine a situation where the user isn't allowed time. There's no time for them to give a decision. They've identified malware or bad code, and they move it right off the books and get it off of that system as soon as possible. Long story short, the Federal Circuit bought it. And the key phrase in the decision is that by making an improvement in computer technology, it was sufficient to warrant an eligible patent. Okay, that got over the bar, and they did quote, the Alice and the Mayo decisions as being part of that inquiry as to whether it made a proper improvement or was substantially different. So there are a lot of now applications pending that have arguably some great room to say that they've also got an improvement on computer technology. So with this great decision, it's a big buttress to a lot of our current inventors that are in this space, SaaS systems, even financial transactions, business methods that are using the computer, as long as they can point to the fact that the computer technology is being improved through their technology, through their invention, they've got a patent eligible and a valid claim in the world. So if you've learned something today, or maybe you'd like to pass this along to someone else, feel free. Please also put a comment below if you have any questions or thoughts about what we talked about today. I'd love to hear from you. I'm your host, JD Hoovener of the Bold Today Show. Go big, go bold.
Go big, go bold at boldip.com.